Good afternoon. We just wanted to welcome you to PilieroMazza's presentation of Government Contract Claims, the top 10 things to know about the Contract Disputes Act. My name is Lauren Brier, and I'm an associate in the Government Contracts Group at PilieroMazza, and I'm here with my colleague, Dozier Gardner. Just to give you a little bit of background about myself, I represent commercial businesses in a variety of government contracting and litigation matters. I currently sit as co-chair of our REA's Claims and Appeals Practice Group, where I primarily assist our small business and large business contractors in preparing REA's certified claims, and then also representing contractors before the Board of Contract Appeals and the Court of Federal Claims, handling claim disputes. And then my colleague here, Dozier. Dozier, would you like to give a little introduction?
Sure. Hi, everyone. My name is Dozier, and I am also an associate who's part of PilieroMazza's Government Contracts Group. I'm also, along with Lauren, part of the Claims and Appeals Group, and I also help guide small businesses through the SBA's many programs and on new contracting vehicles.
All right, thank you, Dozier. Just to give a little background on PilieroMazza's focus, we do a lot of bid protests within our government contracts practice group. We also, like Dozier and I particularly, engage in REA's claims and appeals before the board and Court of Federal Claims. We also assist our clients with mergers and acquisitions, Native American law and tribal advocacy, private equity and venture capital issues, as well as corporate and organizational governance. That's just at a high level, some background on the firm. So as far as what we're going to talk about today, these are just 10 high-level categories that we're going to get into. First, we're going to start off with what is a claim. We're going to get into some more minute discussion on the changes clause and how that plays into filing a claim with the government. Common issues that we see our clients pursue, certain warnings that we provide to our clients as they move through the claim process under the CDA, recommendations that we often give our clients as they prepare claims or as we prepare them in assistance. Our take on using experts and consultants through the claim process and also the appeal process. Just some advice on subcontractor claims, what a government claim is, and then we're also going to discuss common pitfalls that we see our clients run into, and then we're going to do a summary review of what the appeal process looks like when you get a contracting officer final decision that you don't necessarily agree with. So at a high level, what is a claim? So we have a lot of clients that come to us where they've reached an impasse with the government. They've submitted, one or two requests for equitable adjustment. They've tried to negotiate with a contracting officer on particular disputes, and they just cannot get to a resolution. So a lot of times they'll come to us and they'll say, okay, we're ready to up the ante, we're ready to file a claim. So what does that actually mean? So it's a formal dispute that you're filing under the Contract Disputes Act, which is incorporated and referenced into every federal contract. And when you're putting together a claim, it's actually a written demand that gets submitted to the contracting officer directly, and it has to be submitted within 6 years of a claim. So if you're a client and you come to us and the dispute arose 7 years prior, we're likely going to tell you that you're out of time. So the statute of limitations that applies to a claim filed under the Contract Disputes Act is 6 years. In the written demand that you're submitting, one of the requirements is that you do have to request a final decision from the contracting officer. You also have to seek, as a matter of right, the payment of money in a sum certain. So what does a sum certain mean? What it means is a fixed amount. So we can't really submit a certified claim that's relying solely on an estimate. It actually has to be a fixed amount. This is sometimes where a cost expert may come into play, which we'll discuss further in the presentation. One of the other things that you need to request is your adjustment or interpretation of contract terms depending on the facts that you're dealing with and or any other relief that's arising under or relating to the contract. One relief that you cannot seek is injunctive relief or specific performance. So you cannot ask the contracting officer to, you know, stay a certain process or to perform something specific. You also are not always entitled to lost profits or consequential damages. It's very fact specific. I don't want to say you can never recover it, but it is very hard to recover on lost profits. If you are filing a certified claim and that amount exceeds $100,000, you do have to provide a certification. The certification terms can be found under the FAR, but you're basically saying that, you know, the number that we are putting forward is being put forward in good faith and is accurate. The certification does come into play under the False Claims Act. It's basically saying that, you know, you're not submitting a false claim to the government and the number that you're seeking to recover is accurate. So we can go to the next slide. So claims most commonly come into play with disputes under the changes clause of a contract. So under the changes clause, the government has the right to make a unilateral change within the general scope of a contract. So such changes have to be the type specified in the applicable clause. So the changes clause varies between the type of contract that you have. So the changes clause, again, is different if you have a fixed price contract, cost reimbursable, time and materials, or construction. What normally happens is when a change is issued under this clause, it normally results in a written order that's signed by the contracting officer, and it's directing the contractor to make a change that the changes clause authorizes the contracting officer to make. So those types of changes are listed under the particular change clause that's in your contract, whether, like I said, it's fixed price, cost reimbursable, etc. So the right to issue this type of change through a written order is solely within the government's discretion. So the contractor doesn't have a unilateral right to change the contract, nor any entitlement to receive an actual change order. But this is where the issues arise. So most commonly is when you have an informal type of change. So that's a change that's effected through other than formal means. Like you're not actually getting a written order from the government, but they're, you know, say they're giving you a verbal direction and it results in some form of change. So we can go to the next slide. So what does within the general scope mean? So the U.S. Supreme Court says that work within the general scope of the contract is work that should be regarded as fairly and reasonably within the contemplation of the parties when the contract was entered into. So this is a very fact-specific investigation that takes place as far as what the parties' expectations were, as far as what is within the general scope. So an out-of-scope change is often termed as like a cardinal change. You'll also see it termed as a material change to contract terms. As far as, you know, what's in scope, what's out of scope, it's important to note that neither the number nor the cost of changes alone dictates whether a modification may be beyond the scope of the contract. For example, like 200 changes could be held to be within scope. However, the board and the Court of Federal Claims does look at the cumulative effect of a large number of changes. So again, this is determined on a factual basis. It's very fact specific to each particular contract, but when determining in scope, out of scope, the board and the courts will often look at workload volume increases and the level of impact of the change to the scope of performance. So we can go to the next slide. So like I said, most of the time when we have a client that comes to us requesting our assistance on a claim, it ties most commonly to a change issue. So if the government is modifying your scope of work to add, you know, say new or different requirements, you may be entitled to recover additional time and costs associated with performing that new or changed work. The big red flag is that you want to make sure that you're putting the government on timely notice of this change. So say you're getting some directive from the contracting officer, a verbal directive. You want to make sure that you then go back to them in writing saying, you know, we're officially on notice of this change. We're going to be seeking, you know, some type of cost recovery tied to this or a time extension as a result. It's very important that you put the government on notice of these issues as soon as they arise. Especially if you're dealing in a construction contract. These notice requirements are often shorter than your standard 30-day notice requirement under the changes clause. So it's really important, especially when dealing in construction, that you're looking at the notice requirements built into your contract and when you need to notify the contracting officer of any alleged changes. Oftentimes questions arise about whether the change is in or out of scope of the contract. You need to really be prepared to defend by reference to the contract itself. This means, looking at particular points of the performance work statement or the statement of work to basically identify, that this is a carve out. This is something that was not anticipated at the time of award. It cannot be reasonably assumed when looking at the performance work statement. So again, this is something that needs to be considered as you begin preparing a claim that's tied to a change to your contract. You also want to be prepared to detail the justification that you have for additional cost and or time that is necessitated by the change in scope. So one of the trip ups that I see my clients come to us with is they say, well, the contracting officer is making us install 3 additional pipes. It's clearly outside our performance work statement. We want to recover $300,000. And they just are lacking in the cost support. One of the big things that we need from our clients or from anybody preparing a claim that's seeking some form of cost recovery is invoice justification as well as proof of payment. So that is something that you want to make sure that you have organized and ready to provide as an attachment in your claim when you are submitting it to the contracting officer. So we can go to the next slide. So another common issue that we have clients come to us about is delays. So this is an impact in particular to your schedule when you're seeking an extension of time. If your contract is affected by a delay outside of your control, you may be able to pursue time and or cost impacts of the delay. So this, plays into an excusable delay or also a compensable delay. So what is the difference? An excusable delay is something like a weather impact to your contract. Say there's excessive storms that have impacted your ability to perform on a particular construction project. Obviously, that's outside of your control. It's technically outside of the government's control. It's excusable. We want, 60 extra days tacked on to the end of our performance period. A compensable delay is a little bit different. This is when you're seeking cost recovery on top of time. And in order to do so, you need to tie the delay impact to something that has been caused by the government in particular. So it's normally and most commonly tied to interference of performance resulting from the government. So that's like submitting an RFI and the government taking 60 days on the contract so that they had to take 14 days to respond. That would be something that could arguably be compensable because that delay is being driven specifically by the government. So when you're seeking a compensable delay, the damages vary. So you can go after indirect cost increases that occurred during the extended performance period. You could also go after material cost increases that occurred during the delay. So this kind of ties into this idea of trying to recover inflation costs. At time of award, it cost us $1 for lumber pieces. And, now because of inflation and the delay from the government and responding to our RFIs, we're looking at, it being $2. So, all of our lumber purchases has doubled at this point. So that's a good example of going after material cost increases. You can also try to go after lost productivity caused by the delay, and then other damages that you may think of that may be attributable to the delay. Again, you will not be able to recover money for a delay unless you can tie it to government's interference or fault. We can go to the next slide. So another common issue to pursue through the claim process, it ties to contract termination. So if the government terminates your contract for default, this is a little bit different from your standard claim. It's actually deemed a government claim because they're going after you, saying that you defaulted the contract. They then have the right to come after you for re-procurement costs. What happens is once that termination for default gets executed, the contractor then has the automatic right under the CDA to appeal that termination, again, termed a government claim, and to seek conversion of that termination for default to a termination for convenience. One of the things that you need to think through if you do receive a termination for default is if your issues in defense to get that termination for default converted have actually been presented to the contracting officer. So we have, for example, clients that come to us and they say, hey, you know, we just received a termination for default, but we have all these excusable delays that we believe impacted our ability to perform on time. You know, these would be our defenses to this termination for cause. What do we do? So our advice to the client at that point, because the excusable delay arguments have not been before the contracting officer for a determination, we recommend that you appeal the termination for default while also filing a claim arguing that your performance was excusably delayed. On top of that, you know, you may have some other claims. There may be some constructive change issues that you want to go after as part of that claim, but normally that process is done parallel to appealing the termination for cause. On the flip side, if the government terminates your contract for convenience, you are entitled to submit what's called a T4C settlement proposal to recover costs associated with the termination. So depending on the contract type, there's various forms that you need to submit as part of your proposal, whether it's firm fixed price, whether it's cost reimbursable, et cetera. But all is to say, putting your proposal together, it outlines the costs that you believe you're entitled to that resulted from the termination. And also you can seek legal fees as part of that. If you reach an impasse with the government on that settlement proposal for convenience costs, then that becomes a claim. What you would have to do is you'd convert your settlement proposal to a certified claim under the CDA, submit that to a contracting officer then for a final decision. Okay, we can go to the next slide. So another issue that we see from our clients is when they want to challenge a CPARS evaluation. So we've actually seen an increase in these types of claims where we've had a lot of clients come to us wanting to challenge the evaluations that have been put into the CPARS system, whether they want to change, you know, a particular rating that's in the system or even the narrative, whether they want to strike portions of it, get it removed in its entirety. We often assist clients with preparing these types of claims to the contracting officer to try to get some adjustments to those evaluations. One of the big things to know is that when you first receive an unfavorable CPARS evaluation is that you want to immediately get your rebuttal comments into the CPARS system. And when I say immediately, you really want to do this within 14 days from receiving that unfavorable CPARS evaluation. What we often do for our clients is we'll put together a letter directly to the CO on top of putting in rebuttal comments to see if we can get them to remove the CPARS from the system until the dispute is resolved. If you find yourself falling outside that 14-day window, you still should be able to enter rebuttal comments, but it makes it much more challenging to get the CPARS removed from the system while any dispute over the CPARS itself is being resolved. Again, always put your feedback in CPARS. You never want to leave out any rebuttal comments. It's always, you know, always pertinent to make sure that you get those rebuttal comments in. One of the main reasons for that is because if the assessing official's comments are disputed by the contractor in the system, they have to go through a higher review process where they go before a reviewing official for a final determination. Once that final determination comes down from the reviewing official, you then would want to move with filing a claim if you still do not agree with what the evaluation looks like. And then again, that claim will look like your rebuttal comments, but it will have, you know, I would suggest more detail in challenging the CPARS ratings as well as the narratives that are currently in the system. In many of our cases, we have seen that agencies are willing to negotiate or resolve this short of going through the full litigation process, but it is very dependent on the agency attorney that you're dealing with as well as the contracting officer. So there's been some cases where we filed claims on behalf of a client, agency counsel immediately gets involved and we're able to settle, you know, resolve the issues right off the bat. There's other cases that we've had where we filed a CPARS claim, the contracting officer denies that, we then have to appeal to the Board of Contract Appeals, then try to settle with agency counsel. Early on in the process is always recommended, but sometimes it takes a little bit longer to resolve those issues than in normal course just through a claim. So that's just something to keep in mind as you start keeping track of your past performance and CPARS evaluations that are getting generated in the system. So we can go to the next slide. So another common issue that we often pursue is when there's a breach of duty of good faith and fair dealing. So a lot of our clients don't necessarily know that the government has an implied obligation to carry out its duties under a contract in good faith. The big duties here are the duty not to hinder and the duty to cooperate. So this is often used as more of a catch-all argument if we're filing a constructive change claim or even a delay claim. If a client comes to us and says, well, hey, the government interfered with our ability to do X, Y, and Z, that feeds into this idea that, okay, not only do we have a constructive change, but the government also breached their duty of good faith and fair dealing, and this is why. So it doesn't necessarily reach the standard of bad faith, but it is also a requirement that's built into every contract. It helps establish a narrative in your claim to show, that it's what the issues that you are facing in your claim are not within your control. The government had an impact here, and it's important for the contracting officer to recognize and understand that the government has a duty to make sure that things move smoothly during performance. Like I said, this theory of recovery comes up often when the government has in some way frustrated the purpose of the contract. This comes into play when they're not providing information in a timely manner or they're failing to cooperate. A good example would be allowing a contractor on base at certain times. That is an issue we faced before. So these are all, common issues that we find our clients bringing to us that they want enveloped in a claim. So all things to consider, if you do find yourself in an impasse with a contracting officer and particular arguments are available to you. So we can go to the next slide. So I'm going to pass the microphone over to my colleague, Dozier. Would you like to get started?
Yes, thank you, Lauren. So one of the warnings we'd like to give clients about filing a claim or before they file the claim is, or one warning is, when is the government bound? Or put differently, when is the government essentially responsible for the things that it has asked you to do? And here the government is bound when the appropriate government official has acted within the scope of his or her actual authority. And something to be careful of here is be careful to accept direction on a contract from an official that is not authorized. And this can be kind of tricky when you're working on a contract and there are multiple government officials giving directions or explaining things, and you really need to know which one is authorized to actually give those instructions. Because if they're not authorized to give those instructions, say someone who isn't tells you to do XYZ on a contract, you perform XYZ, and you go to submit a claim to recover those additional costs, the government can turn around and say, well, we weren't bound by that official. They didn't have the actual authority to do so. Therefore, we're not responsible for paying you that additional money and completing XYZ. So the government can also be bound if the official acted with implied actual authority. This is a little tricky, and it may arise when the government intends to grant authority but failed to do so, and the authority would be an integral part of the duties assigned to that official. As I said, this can be a bit tricky to determine when there is actually implied authority, and it can come down to a very factual determination. So we always recommend don't bet the farm on implied actual authority, because there's a chance that it could come down that there wasn't this implied actual authority, and then you're out of luck with those additional implied costs, incurred costs. And then finally, an authorized representative of the government who does have the actual authority to bind the government can later ratify decisions that are made by or instructions given by those unauthorized officials. This would typically happen if, say, an unauthorized official did tell you to do XYZ. That later went up the chain to someone like the contracting officer who does have authority, and they sign off on it and pretty much accept that work therefore you have someone with authority ratifying it. And then those claims would become then those additional costs would be something you can make a claim on. We can go to the next slide, please. So another warning and something to always pay attention to are waivers and reservations of rights. Typically, waiver language can be included in modifications or amendments, and these are typically pretty sweeping waivers that release the government from any liability for any action or inaction prior to that modification. And these can be complete bars to recovery. So you really want to be careful when you're signing any modifications or any additional documentation that goes along with your contract, so you aren't waiving your rights to then file a claim. Also, reserving your rights if you believe you have a claim is always it's always prudent to do. This can either take the form of having the government remove the waiver or release language, or you can add your own language into, or request your own language be added in that explicitly reserves your right to file a claim in the future, and then describe the issues you would like to reserve that right for. And this really helps to ensure that you are going to have that right to then file the claim. Next slide, please. So as you're going through the claims process and determining whether to file a claim or not, we have a few recommendations. First and foremost is to involve an attorney in claim investigation, preparation, and negotiation. As Lauren was saying earlier, a lot of these common issues that arise with claims are very fact dependent, and it really helps to involve an attorney who's experienced with these issues, who can help get the facts straight and determine what is and is not a relevant fact, and what facts really help push your claim forward and gets you closer to that success, gets you closer to recovering the time, costs, or both that you're seeking. Another very helpful thing in preparing your claim and later in the appeals process is having consultants or experts. Consultants and experts are very helpful in determining exact costs or determining the exact amount of days that you have been delayed and putting together an accurate claim, which we'll discuss in a minute is very important to do to make sure that you've accurately calculated everything in your claim. So you also really want to have solid legal grounds. And by having solid legal grounds, you increase your chance for success, but you also minimize your false claims risk. Something that can come up is if you submit a claim and you're unable to support your claim, support the cost that you're seeking, the government could come back and say that you've submitted a fraudulent claim and then come at you for damages and other costs, which is something you always want to avoid. And again, why having an attorney or experts and consultants is very helpful, because they can accurately determine the exact amounts that you can support. And this leads into this next part about negotiation. The claim process, the claim itself, is not necessarily a tool to negotiate. This is not a tool where you want to put the highest number you think you can get and then hope the government comes down from that. That's a reference to this case Daewoo, which was a very large case where a contractor submitted a claim that they knew was well over the amount they could prove as an attempt to negotiate. The government came back and said that was a false claims violation, and the court agreed. So you really want to avoid putting anything in your claim that you can't prove, or you can't prove, because that can lead you into some liability and then get you on the hook for damages. And it's always better if you do enter into a negotiation, it's always better to come to an overall compromise on the contract than to go line by line. The Federal Acquisition Regulations specifically say the contracting officers are looking to negotiate a deal over the entire contract. So it typically helps to negotiate in a similar fashion. That way everyone can come to an agreement that's beneficial. Next slide, please. So a little bit more about using experts and consultants. Like I mentioned, if you're going to be filing a claim, you need to be able to put forth exactly how you got to the amount you're claiming and support that amount. And the amount has to be calculated based on reliable principles and methods. Now, there isn't one exact reliable principle or methods, but this is where it helps having an expert or a consultant who would be well versed in specific principles and methods and can clearly explain how they use these principles and methods to come to the conclusions that you are owed X amount of money or a certain amount of days worth of a delay. Also, you really want to get the exact amount of your claim, because if your claim is over $100,000, a certification is required by by a party who's making the claim. And if you don't, there's potential for False Claims Act liability, which again is heightened by the need, heightens the need to ensure your claim is accurate. And for these reasons, expert and consultants are prudent in most cases to calculate damages, since you really want to ensure you are not putting yourself in additional risk for a False Claims Act, while also ensuring that you're going to recover the maximum amount possible for your claim. So we typically like to recommend using experts and consultants in these situations to make sure everything is as clear and is able to be supported as best as possible.
Yeah, and Dozier, I'm going to chime in just briefly on this as well. So we also like to use experts and consultants for technical aspects. And from my perspective, it's very helpful if you're reaching an impasse with a contracting officer on a very specific technical dispute, to reach out to an expert and consultant to prepare a third-party report. The reason why I find it fruitful is because it's been helpful to us to resolve issues before getting to have to appeal a claim. If a contracting officer has consistently taken a position on a technical dispute and they're unwilling to budge, sometimes it's just a matter of getting a third party, somebody independent to the performance, to take a look at the technical aspects that are in dispute, and then to generate a report that you can then present to the CO. And then if the CO, doesn't want to consider it, you envelope it into the claim, you submit it, and then it automatically becomes a part of the record on appeal. So it's never a waste to bring in an expert consultant at the claim phase. I only find it to be helpful, beneficial in negotiations and trying to get a CO to the table, especially when they've been, adversarial throughout the process and unwilling to, consider your position on a technical dispute. So we can continue. Sorry.
No, thank you, Lauren. Experts are always very useful. Like she said, we always do recommend them, especially as it helps get another third party in there that can give a more objective view of the facts. Now, once you submit your claim, say there's no negotiated settlement between submitting the claim and the final decision, what's going to happen next is the final decision. Now, this is a very important part of the claims process, as this is what kicks off the ability to then appeal. However, before we get there, the final decision itself is, like it says, it's a final decision written from the contracting officer. And there are two things: it must be in writing and it must be final. Now, the FAR does have language in there that this contracting officers can pretty much copy and paste that determines that this is a final decision. So if you do get something from a contracting officer that seems like it could be final, it could be prudent to check this language against what the FAR recommends to actually determine whether this could be a final decision or not. And the final decision must also be responsive to the claim and state the reasons for the decision being reached. So say the contracting officer reaches out and says, I've made a decision, I'm denying it, but they don't give you any reasons. That's not sufficient to constitute a final decision. It's got to be responsive to what was written in the claim and give the reasons why the contracting officer has reached the decision that they have, whether to deny it or grant it in part or fully grant it. And typically, the final decision is due within 60 days once you've submitted your claim. We see this quite a bit where a CO will seek additional time, and depending on the complexity of the claim, this can actually be beneficial, because usually if they're taking time to dig into the claim, that tends to mean that they are reviewing this carefully and they're trying to figure out the best path forward. And usually we do tend to agree to these extensions, because at this stage we don't want to put the CO under too much pressure and possibly have them make a decision that, is wrong. It usually helps to give them that time to work through claims, especially more complex ones, so we reach either a right decision or we get a fully fleshed out reasoning behind their decisions. And along with this 60 days, there is something called a deemed denial, which is where the contracting officer within those 60 days, if they don't request an extension or they don't agree to an extension, fails to issue this final decision. And what this means is they have effectively denied the claim. And this pretty much acts like the final decision and then allows you to pursue your appeal rights after. Next slide, please. And so we'd just like to touch base on subcontractor claims, which work a little differently than your typical claim. Here, the general rule is a claim has to be filed by a party to the contract. And for CDA purposes, the contract is between the contractor and the government. The subcontractor is not involved in that contract. So what happens is what we call pass-through claims, which is where the prime will sponsor a claim on behalf of the subcontractor, and then the prime, who is a party to the contract, can bring that claim for the subcontractor. So the prime is permitted but is not required to submit these claims on behalf of the subcontractor. And like other claims, certification is required for claims of over $100,000. So that's important to know. If you're ever going to sponsor a claim for your subcontractor, you need to make sure that that is certified. And you can also sign a certificate of good ground for the claim, signing a certificate saying that you believe there are good grounds to be filing this claim on behalf of the subcontractor. And regarding the prime's obligations to review and audit the subcontractor claims, the cases are inconsistent. However, at minimum, you need to review the claim before certifying it. And while that's an obligation, that's also just prudent to do to make sure the claim is supported and there's nothing in the claim that could potentially open you up to liability or present a problem for the subcontractor or yourself. And here you can also qualify your certification. For example, use language that you don't believe the claim is overstated, or to your knowledge, you don't believe that there are any improprieties with the claim. And this helps qualify you later down the line if there were problems that didn't get noticed that come up from additional information. You can point to this certification and say, well, at the time, our knowledge was XYZ. So that's an area where there might be a little wiggle room where you can add that qualifying language to protect you down the line. Next slide, please. There are also government claims, which procedurally, these are a little odd, where all claims by the government against a contractor require a formal decision by the contracting officer. And once the receipt of the contracting officer's decision regarding a government claim triggers the period to file an appeal or suit under the CDA. And the reason this is a little strange is if the government is the one making a claim against the contractor, yet under the CDA, the contractor is the one who is required to file the complaint and start the appeal, which is procedurally a little bit backwards from how things normally work. However, a lot of the times the government fails to follow procedure and will simply impose an offset, which is the government offsetting the cost that it's claiming against the amount the contractor will claim under the as part of their claim. So instead of fully bringing their own claim to fruition, they'll simply enter into an offset and take away the money that you could potentially get from your claim to satisfy their claim. So it's a little procedurally confusing. However, we do see this come up time to time. And I believe I will throw this back to Lauren for the next slides.
Thank you, Dozier. So just to provide a quick summary on the common pitfalls of claims that we, ran through earlier, the one big one that we see is accepting direction for changes from an unauthorized official or without following the proper channels to confirm a change in scope. So again, the big ticket items here are just making sure that you're getting a directive in writing, if you can, from the contracting officer themselves. The other thing is that you want to make sure that you're following the proper procedure when noticing the government of changes. Make sure you understand the notice timelines and requirements that are built into your contract. Some have 30-day notice requirements, some have 10, some have 14. Again, it's very important to understand what those requirements are because they can, rear their ugly head and prevent you from recovery. Another big issue that we see is signing a release in a prior modification or amendment that waives your rights. We have some clients that come to us and they say, well, I felt like I had to sign this modification even though it had release language in it. That is not always the case. We often recommend that you provide pushback. We've drafted release language for our clients to implement into a modification and send it back to the contracting officer for consideration. That has been successful. Or we, will strike portions of the release language to carve out particular REAs or claims that you believe you want to file. So, recommendation there is to always try to push back on signing any type of modification that contains release language. Another big trip up for our clients is poor, insufficient record keeping. You always want to make sure that you're keeping track of daily reports, daily logs, timesheets. All of that information is really important to build out in your claim as supporting evidence. So you want to make sure that you're just constantly documenting as soon as you see an issue or you have a feeling that this is going to become a dispute with the government, start taking notes and keeping track of the issues that are surrounding that, making sure that you're collecting written correspondence. All of that is very important. Like I said before, failing to provide timely notice to the government is a huge trip up for some of our clients. As a subcontractor, you always want to make sure when you're executing a subcontract that there's language in there that allows the contractor, the prime contractor, to sponsor your claim. You don't want to be in the position where you feel like you have a legitimate claim for cost or time, and then the prime contractor is not willing to sponsor that. You're non-privity with the government, so it will make it very difficult on you to be able to recover that cost or time on your performance. Another issue that we see is clients that fail to tie their request for recovery to a legal theory. That's where we come in and are able to provide assistance. If you're unsure as to how, or why you're entitled to recovery on time or cost, it's always very important to provide some legal analysis applied to the facts that you're dealing with to ensure that you get a positive final decision from the contracting officer in response to your claim. Another big issue is just a misinterpretation of the contract terms. Sometimes we have clients that come to us and they're just not applying a reasonable interpretation. So sometimes that can be a trip up, and that's why you're at an impasse with the government. So we can go to the next slide. So as far as appeal rates go, so when you get that final decision that Dozier referenced earlier, and it's denying your claim, or sometimes it's denying your claim in part. So, sometimes the government may come back and say, hey, we'll give you an extension of your performance period, but we do not believe you're entitled to cost recovery. You can actually appeal that one portion of the denial and allow that period of performance to be extended while appealing the cost denial. So if your claim is denied, what are your options? There's two. You can either appeal to the Board of Contract Appeals or the Court of Federal Claims. Some agencies have their own Board of Contract Appeals, like the Postal Service and the FAA, but the two big ones are the Armed Services Board of Contract Appeals, who oversees all DoD contracts, and then there's the Civilian Board of Contract Appeals, who oversees the civilian agencies. And the big thing to know when appealing a final decision is your timeline. So if you're wanting to appeal to the Board of Contract Appeals, your deadline is 90 days from the date of the final decision. And then the Court of Federal Claims deadline is you have 12 months from the date of the final decision to appeal the claim to the Court of Federal Claims. So there are definitely pros and cons to both forums. Again, it really comes down to fact-specific issues of whether you would want to appeal to the Board of Contract Appeals or whether you'd want to appeal to the Court of Federal Claims. From my perspective, the Board of Contract Appeals judges are more in tune to government contract issues because that's all they look at. The Court of Federal Claims, they deal with, various issues outside of government contracts, so it's not filling up their entire docket. Oftentimes, the Board of Contract Appeals can be a little less expensive because you're dealing with an administrative law judge. The process is a little less formal. I mean, it still abides by the federal rules, but it's not as buttoned up as the Court of Federal Claims. So your costs may be, I would say a little less than going to the court. If you get a decision from the Court of Federal Claims or the Board of Contract Appeals not in your favor, you can then further appeal that decision to the U.S. Court of Appeals for the Federal Circuit. So once you do choose your forum, that is your forum. So once you go to the Board of Contract Appeals, that's where you are. And then you can appeal to the Federal Circuit. Same thing goes for the Court of Federal Claims. Once you go to COFC, your only option from that point is to appeal to the Federal Circuit. One of the benefits actually with both forums is that the judges do encourage engaging in alternative dispute resolution, which is available, like I said, in both. And that can look in various different ways as far as mediation. Sometimes with the board, the ALJ that gets assigned to your case will assign a mediator to sit down with the parties to try to mediate any conflicts or issues that are in dispute to try to readily resolve the concerns. Same thing goes for COFC, where you can go into, if the parties agree, some form of alternative dispute resolution to encourage settlement. This process can actually be used before or after the final decision is issued. So, sometimes you'll file a claim with the contracting officer and they'll reach out to you and say, hey, why don't we bring in a mediator here? And before I issue my final decision, we'll see what they have to say as an independent third party. That often can be very beneficial and encourage a resolution of the issues. Or, sometimes the contracting officer will issue the final decision, but then be amenable to mediation subsequent to that. Saying, don't file an appeal, we'll try to mediate at this juncture. Or another alternative is going through the mediation settlement process after you file the appeal, and agency counsel or DOJ under COFC gets involved. Again, in order to go into any of these ADR processes, it has to be voluntary from both sides. So just because we're willing to go into mediation, the agency is not always willing to do that. Most commonly, when they're not willing, what they'll do is they'll say, hey, we'll go through discovery, we'll go through a request for production, we'll see what the papers look like, we'll exchange documents, and then we'll consider going through the alternative dispute resolution process. So a lot of times the agency will say no from the get-go, but then once you go through the discovery process, they're more willing to actually engage in ADR. So we can go to the next slide. So I believe, Dozier, I'm going to hand the microphone back to you for this one.
Thanks, Lauren. So now we'll talk a little bit about some of the differences between going to the board and going to the Court of Federal Claims. So at the Board of Contract Appeals, both the ASBCA and CBCA, you file your notice of appeal. And once that happens, the government, it's then on them to prepare the appeal file. And this is what's also known as a Rule 4 file. It contains information like the contracting officer's final decision, a copy of the claim, relevant communications between the parties related to the claim, and pretty much any information that's going to be relevant to the claim. The government then has the burden to put that together and submit it to the board. That right there is very helpful. It's very beneficial to see that information relatively soon after filing the notice of appeal, because that gives you a good look at information that wasn't previously available and also helps get an idea of where you're going to want to take discovery after that, like what documents to follow up on, where to get more information from, and things like that. You also can get into motions practice, which is having your attorneys file motions back and forth. And these are very helpful in narrowing down, say, the scope of the issues or dispensing with certain defenses the government has. And this can help really push things along, and it can also help get the government to the negotiating table, which sometimes is just the best resolution if you don't want to go all the way through with litigation. But you also have the ability to do discovery with the board. Similar to a regular court, you can have requests for document productions, requests for admissions, depositions, and interrogatories. All these tools you have at your dispense before the board to get more information from the government and to further flesh out your claims and see where your best arguments are. Next slide, please. And another interesting thing for the Board of Contract Appeals is that you can have hearings, however, they are optional. And if you do decide to have a hearing, the board can hold these hearings in a location that best serves the interest of the parties and the board, which is convenient for parties who are maybe across the country from where the board is in DC, and the board judges can then travel to you, have that hearing, and that can also save costs from having to travel, having to put up a hotel while your hearing is going on, and things like that. The board can also issue witness subpoenas and bring in witnesses similar to a trial. So as Lauren mentioned, these are a bit more informal and they're not as rigid as the Court of Federal Claims, but these hearings do operate very similar to a trial in the way that evidence is presented, like calling witnesses, putting them up there for examination. And another thing to know is that the government will be represented by agency counsel. And this can be beneficial as an agency counsel is going to be a bit more familiar with the agency itself and how they do things than a DOJ counsel, which will be used for Court of Federal Claims appeals. And this can be helpful if you're working through a pretty complex claim. It may be beneficial to have an agency counsel there who understands the regulations and the law maybe a bit better and their nuances to go through this. And in the alternative to a hearing, there can be a submission of the case without a hearing. This would be putting together a large brief setting forth your arguments and including affidavits, discovery responses, and other stipulations the parties agreed to prove key facts. And this again can also avoid some costs of having to appear in court and get witnesses and things like that. Next slide, please. So you also can choose to go to the Court of Federal Claims. So structurally, it's a bit similar. It's pretty similar to the Board of Contract Appeals, whereas here you file your pleading, which would typically be your complaint. Then it will go into discovery, where you'll have all the tools I just mentioned for the Board of Contract Appeals. And then you can move into a trial, which will be much more formal than a Board of Contract Appeals hearing. Here you'll have the one judge from the Court of Federal Claims, and you will present your cases as a normal trial would go. And you can also submit briefs to the court. Here it is a little different because you'll be subject to the federal rules of civil procedure and the federal rules of evidence, whereas with the board, they have their own rules of procedure. So it's always good to take a look at have the attorneys review those rules to determine which ones potentially could be more favorable. And here, as I mentioned previously, the government is represented by the Department of Justice, and these attorneys aren't working for the agency, so they don't necessarily have background knowledge into the agency or perhaps the procurement. So sometimes it can be helpful if you're litigating against a Department of Justice attorney who may not know the regulations and the nuances of government contracting as well as agency counsel would. But these are all considerations to take into when deciding whether to go to the Court of Federal Claims or Board of Contract Appeals on appeal. Next slide, please. And yeah, so thank you all for listening. And I think now Lauren and I will field any questions.
Yeah, so I did address, I think, everyone's question that's in the question box through the webinar system. But if you do have questions, as you can see on the slide, Dozier and myself, our email and contact information is all there. So if there are any lingering questions that you may have or that you think of after the fact, feel free to shoot us an email. We're happy to respond or even jump on a call if you have any questions pertaining to the presentation. We just wanted to say thank you for joining us this afternoon. We appreciate everyone that has taken the time to learn a little bit more about the CDA. And we hope to speak with everyone soon. Thank you again.